Good afternoon and welcome from lockdown Leicestershire in our latest of a series of free webinars which is called Working with the Legal Aid Agency. I'm really pleased that the LAA have agreed to join us and deliver this webinar jointly. Today's presenters are Jill Waring and Steve Keeling. Jill has worked for the Legal Aid Agency for 17 years. And as a National Contract Manager, she has responsibility for the contract management and quality assurance teams in London and the South East. She also has responsibility for the peer review team. She will be joined by Anthony Evans and Stephen Barker from the LAA case management team. As you may know, Steve was a contract manager I trained 20 years ago. In his cohort were a range of very interesting characters, including the current chief executive of the LAA, Jane Harbottle, so I guess it must have been the great training she had. Now, some delegates have asked questions in advance of today. These will be answered during the webinar. You may also ask questions using a chat facility, which I'll monitor. At the end of the presentation, I'll put forward some or all of the questions you've asked, depending on how many there are. We will ensure that any unanswered questions are answered after the event, and we'll publish all Q&As on our website. Please may I ask that questions remain questions and are not statements. Now, before we begin, I know that Jill wants to address a current IT problem. So over to you, Jill.
Here we go. Can you hear me?
Yeah, perfectly.
Yeah, thank you. Yeah, I just, in particular for any civil providers who are on the call, before we start and get into all the detail of COVID and the recovery work and different things that we're doing, I just really wanted to acknowledge and apologise for the fact that we've had significant problems with CCMS for the past few days. I think we're now in day 3 of the issues, and we have invoked the contingency process for applications. Unfortunately, I can't add much more other than to say we are working around the clock to try and fix it, and it's our absolute priority at the moment. We do not for a second underestimate the impact it will be having on you. It has an impact anyway, but particularly at the moment with the additional stresses and different ways of working that are going on. So it was really just an apology, and just to reassure you that we are doing absolutely everything we can to try and resolve the problem. What I would say is just keep an eye on the website, keep an eye on the usual channels, the Twitter feed, all of the places where you would usually look for updates from us to check for any updates or any changes. But that was all I wanted to say about it. But I just really wanted to address that.
Okay, thanks, Jill. Hello, everyone. My name's Steve. As David already said, we've asked for questions in advance of today, and some of those questions will be answered within the presentation itself. With other questions, we're going to pause every 2 or 3 slides, and we'll put some more of those questions to the LAA at the end of the relevant section and have a bit of a discussion around them. So the agenda for today, we'll talk first of all about the COVID-19 guidance, where you can find it, and some recent updates have been to that. And then we'll look a bit more in depth at some of those areas that are covered in the guidance. So auditing, contract management, processing claims, and financial support available to providers. And once we get to the end of the presentation, we'll also have a chat with Jill about what comes next, what the LAA's thinking is for the next few months as hopefully we start to emerge from lockdown. So the COVID-19 guidance, I imagine the vast majority of you will be quite familiar with this now. If you've not seen it, it's available on the LAA's website via its homepage in great big letters, so you can't really miss it. There's advice on areas such as remote working, processing of claims and payments, working with clients, and contract management and assurance. There's also separate sections looking at LAA contingency plans and also financial relief measures. And the most recent update came through last week, and that now includes some dates when certain activities will become operational again or start to become operational again. And we'll mention those as we go throughout the presentation. The links to these particular areas of guidance on the LAA's website are provided on the final slide for today's presentation. But if you go on there and have a look, there are far more detailed links and guidance within the LAA's own presentation to cover some of the headlines that we'll be going through today. So first off, we'll look at auditing and contract management. The LAA's approach to this has been to suspend pretty much all audit activity since early March, with the aim of reducing administrative burden on providers at this time. One of the first questions they had to address back in March was office and supervisory requirements under the contract. Obviously lots of firms shutting premises down or working with a skeleton staff, clients not being seen in the office, and supervisors perhaps unable to work or unable to come in the office, maybe even being furloughed. The LAA have taken a flexible approach to this and continue to do so for now, just encouraging providers to discuss any issues with their contract manager in the first instance, and particularly with regard to supervision, if you are now having remote supervision, just to talk to them a little bit about how you're maintaining the supervisory standards and requirements and checking the quality of the work, etc. Where you've furloughed staff, just to talk to them about kind of temporary arrangements in place if you're struggling to cover supervision. Mentioned that announcement earlier last week. So core testing is due to begin again from the 6th of July. Core testing, if you don't know, that'll be the audit where you get a letter through the post asking you to send one file in, and it's the audit that's done under the supervision of the NAO. Really important audit from the LAA's perspective. They will be showing some flexibility in terms of what information you can get to them and how long it will take you to do so. So obviously if you can send the information in, if you're in the office or you've got it digitally, you should have no problem. Where you're struggling, contact your contract manager as soon as possible to discuss any difficulties you might have being able to evidence the claim. And then once we get into August, peer review and the startup of contract management activities will happen again. And Jill tells me that CMs are in the process of contacting providers by email now. So it may be that you've had an email, or if not, you're likely to get one over the next week or two. So we'll just pause there and I'll come to Jill now. So first of all, do you just want to talk a little bit about the general approach the LAA's taken and what to expect over the coming months?
Yeah, thanks, Steve. So, in terms of the pause in activity, as Steve said, is exactly the reason why we did it, is to reduce the administrative burden. We recognise that particularly back in sort of March and April, providers, like all of us, were grappling with new ways of working and trying to keep their staff safe, and some really fundamental issues that we needed to deprioritise our activity. As you say, we are starting to sort of have a kind of path to restarting our activity. So core testing will start from next week. Some of you may well not be impacted by that because core testing is completely random. So it's done in a way that tests the schemes overall rather than individual providers. So some of you may not get requests for files for that. But if you do, like Steve says, and you have issues with getting files to us, then let us know, talk to the core testing team and to your contract manager and sort of explain what the difficulties are, and we can take it from there. In terms of peer review and contract management, we will be writing to all providers individually just to give a bit more detail about what that means. But again, so peer review, for example, we'll be starting with some of the high risk work. So things like if a provider's had a below competence peer review and they've been due a follow-up review during this period, then that will be prioritised after the work restarts. But again, if there are difficulties, if you're due a peer review and you ask for files and there are difficulties with it, then what we'd really urge you to do is communicate with us about it and tell us if there are any difficulties. Similarly with contract management activity, I think it's probably fair to say that our main priority will still be what it has been, which is just continuing to understand what the impact has been of COVID on you and your business and what some of your challenges are, and trying to work through some of that with you. As I say, you'll all receive an individual email, and it may well be that you've had an annual visit, say back in January, and you haven't got another one due till next January, and that actually you'll see very little in terms of contract management activity over the next few months. It may be that there was some activity that was due during the kind of lockdown period that we'll want to try and restart. But again, the most important thing is that you talk to us about any difficulties that you've got, either with getting files or with personnel because of people that are furloughed or anything like that. We know that there will be a lot of different issues facing the provider base. So what the clear message I suppose I would want to give is the 1st of August start date, particularly for contract management activity, is about us starting to contact you and starting to do that activity. It certainly won't be a kind of big bang and everybody will be getting a contact from us in the short term.
Okay, great. Thanks, Jill. One of the questions we received several times really in different guises was around the requirements for permanent presence and office requirements now that flexible working has been introduced for the period during the pandemic. Obviously, a lot of providers have got a big cost base here when it comes to running the offices, and there's certainly interest in whether the LAA might kind of adopt different criteria going forward when it relates to that.
Yeah, so I guess picking up offices in particular, as you say, in contingency guidance, we've said, we won't take action where you're not able to meet the office requirements. The next decision is, and this is the way that we're approaching all of the contingency measures, is do we need to revert back to the previous position? To get to that point, we've got to do a lot of detailed assessment of, the risk and the issues and talk to providers and talk to vet bodies. If we decide we do want to revert to the previous position on any of the contingency measures, the next step is to set out what is our roadmap for doing that. So giving providers as much notice as we possibly can to say, this is the point at which we would want you. So to use the office as an example, if we decide that that's a position we want to revert to, that we say, this is the point by which we would expect your office to be operational. So that there's still lots of ifs and buts, I think, there, but I guess it's just to try and explain to you the process that we're going through at the moment. And the current guidance has been extended till the end of July, and we will give you as much notice and as much information as we possibly can at every stage. And I think the other thing just to acknowledge is everything is changing as well. So we don't know what is going to happen in the wider world. We've seen the news about Leicester. We don't know. So at the moment, we're working on the basis that obviously things will continue to get better and likely to continue, starting to get more normal, but that could well change as well. So we are going to have to continue to be responsive.
Yeah, I think everyone appreciates it's hard to predict, whether things are going to get better or worse over the next period. But the question really drives at, is it on the LAA's radar, I think, to consider whether there might be some changes to kind of the more rigid structures in place around requiring an office in certain circumstances. I guess the answer to that is yes, watch this space, is it?
Yeah, it's definitely on our radar. And there's a question about the current contract and then any future contracts as well. And that position could be different for each one or could be the same. We just don't know yet, but we are starting to work through that.
Okay, brilliant, thanks. Okay, so we'll move on and look in more detail at some of the things that might come up on audits or your contract manager visits over the next few months. So there's guidance on digital signatures or where those signatures can't be obtained by the client. So when it comes to digital signatures, the LAA guidance refers to Law Society guidance or a Law Society practice note on that particular area. So for example, returning signed documents or just a signed page of a document, there's actually a practice note that you can click on and have a look at. And as long as you're within those guidelines, then the LAA will accept a digital signature. The LAA guidance specifically states that text message replies will not constitute a digital signature. Where you're not even able to obtain a digital signature, you are allowed to continue with the matter, providing you put a note on the file and a note on the form itself and have that note signed by your supervisor. And you must detail what steps you've taken to try to get the signature, why you've not been able to get it, and provide some evidence, whether it's an email exchange or an attendance note from a telephone call, to show that the client has signalled their intent to sign the form. Finally, you should also look to obtain that signature when it's appropriate to do so at the right time. So just because you've kind of gone through this process back in April or May, the matter's still open in September, but perhaps things have returned to normal, you should try to get your client's signature on the form at that point. When it comes to crime, virtual remand hearings, court duty attendance, police station attendances, remote attendances can be claimed as face-to-face attendances. When it comes to remand hearings, it's important not to confuse it with virtual court. So virtual court is something that exists within the LAA contract and is paid under a different payment scheme. Virtual remand hearings are not virtual courts. They are just magistrates' court attendances where you would have attended normally, but a remote attendance has been signed off. You just claim them through the usual magistrate court scheme. When it comes to police station attendances, there's going to be a differential between usual telephone advice, your IMVB claims, and a police station attendance claim, your IMVC claims. It's important that you note the reasons for non-attendance on the file and that you put a detailed advice note on there so that when the LAA come to audit that, they can see the difference between whether it would have been just an ordinary telephone call claim or an actual attendance claim. Also, when speaking to crime, the LAA guidance, to crime clients, the LAA guidance makes clear that you can claim for telephone advice where the client is at home due to Public Health England or NHS guidelines. Mental health, the remote tribunals, where the tribunals are for the purpose of disposing of the case and take place remotely, you can still claim your full level 3 fee. In family, the gateway requirements for domestic abuse and child abuse eligibility, they've been relaxed for the period of the pandemic. So certain requirements where you'd have to get a letter on a letterhead, for example, from a domestic violence agency, the letterhead is no longer required. They've expanded what can be provided via email. And when you're dealing with the police about caution or an ongoing investigation, you can now provide an email or a note of a call with the police confirming that that's taking place if you can't get the full evidence. When it comes to assessment of financial eligibility for clients, the guidance says you must take reasonable steps to collect what guidance you can. That can be via post or email, and document those steps where no evidence can be obtained or perhaps you've only obtained part of the evidence you require. You must also, a bit like the digital signatures, try to obtain any of the missing guidance when you can. And finally, the emergency certificates, I'm not quite sure whether this fits into contract management, but certainly it might be picked up on core testing, so it's worth a mention. With emergency certificates, scope and cost limits have been extended, so the scope's widened out. Emergencies now last for 12 weeks rather than 8 weeks, and the cost limitation has been up to £2,500. And along with extending times, for example, for delegated function applications and substantive amendments, those processes have been put in place to assist you when emergency certificates are being granted. Continuing with auditing and contract management, the requirements for duty solicitors and police station accredited reps, so duty solicitors, they must do a spread of cases and 14 hours of CJS work each week. They are excused during the period of the pandemic so long as they have made a note on their duty solicitor records explaining why, whether they're furloughed perhaps, or they're shielding at home, or maybe they are working but there's just a reduction in the amount of work coming through at the moment. For duty solicitors, the usual swap mechanisms for swapping rota slots is in place, but it's also been extended to covering neighbouring schemes if you're struggling to swap within your own rota. For the police station reps, those probationary reps looking to qualify but can't get their full number of cases in for the portfolio, that qualifying period has been extended to the end of September. Police station accredited reps, a bit like duty solicitors with their cases, are also required to do 25 police stations every 12 months. The guidance doesn't specifically state that they're excused, but along the lines of the duty solicitor guidance, if people can't meet that 25 because of an extended period of furlough or shielding, etc., there'll be some flexibility around that, providing their records are noted. Mental health designated accredited reps, like crime duty solicitors, also have to do 14 hours of mental health work per week, and as the same as duty solicitors, are excused from that 14 hours, providing their record notes the reasons why. When it comes to supervisors, depending on the category of law, in order to qualify as supervisor, you quite often have to have a range of caseload or a number of cases that you have to do in 12 months. And the majority of supervisory requirements still require 350 hours of caseload in a year. And for people, especially people with prolonged absences from work, that might prove difficult as well. So the LAA have indicated that there will be flexibility in discussing those requirements and allowing people time, a reasonable length of time, to bring themselves back up to the minimum standards in these areas. And in a moment, we'll have some questions on that, so we'll get Jill's thoughts. But just before we do, we'll talk about quality mark. So whether you're Excel or SQM, there are options available at the moment for remote audits to take place. Both standards are allowing on-site visits, whether they're kind of wholly on-site audits or partial on-site with a bit more of a remote element to them, but both are requiring you go through a health and safety assessment with your auditor before those take place. Now, for SQM purposes, the decisions on this are come down from the LAA, and the arrangements for SQM are currently only in place till the end of July. We're still waiting to see what happens from August and beyond, awaiting an announcement on that. If you don't want to go for the remote audit option, it's not feasible, and you don't want someone on site, there is the ability to postpone. With Lexel, I believe remote assessments can be booked in up to as far as December currently, and they're also allowing postponements, but only up to the end of July. Certainly, you're having to speak to your auditor and outline exceptional circumstances if you want to delay an assessment that's due before the end of July. Okay, so we had probably the most number of questions, Jill, in this particular area, so I've got quite a few to run through with you. Yeah. First off, one of the questions we got was, how are you going to ensure that contract managers take a consistent approach to applying this guidance?
Yeah, so it is a really good question. So very early on in the contingency planning, we set up a consistency group across the LAA, which is made up of an individual from each contract management team, as well as national leads and colleagues from people like our service development team and commissioning teams. So our intention is that we'll continue to use that throughout, so that if they or any people in their teams have a query or aren't clear how to apply the contingency guidance, then they bring that to the consistency team and we agree, a consistent response across the country.
Okay, thanks. There's a bit of nervousness around these temporary measures, and when people are being audited 6-12 months hence, what date did they come in, when did that particular requirement stop, that particular guidance stop being applicable. Are there any plans to publish a kind of set of dates from and to when the guidance was applicable?
Yeah, so as I said before, I think the intention is certainly to set out, not just to say this is going to end on this date, but to set out kind of our roadmap of where we want to go with all of it, sort of in the short and medium, longer term. As part of that, what I'm sort of aiming for at the moment is on the website, we have a table that has what the measure is, when it started, and if it's ended, the point at which it's ended, or if it's ongoing and has become business as usual, so that we've got that all in one place, because I am conscious of the fact that obviously the guidance has grown and, got quite unwieldy in places, albeit we've tried to sort of put it into some sort of structure. So that is the next step, is to have a kind of one-stop page on the website. Okay,
and I think you may have touched on this earlier, but are any other changes likely to stay in place more permanently, do you think?
Yeah, so I guess the most important thing to say is the default position isn't that we will revert back. So we're not approaching this as, when can we go back to how things were before? Every single measure will be looked at in detail and scrutinised by people from across the LAA, so not just the the part of the business who maybe implemented it. Everybody will get a chance to look at it, and we'll obviously be speaking to our consultative groups at the right time to say, actually, what's been the impact of us doing this? Could this just become the business as usual position? And I think there are certain things which I'm pretty certain, and I imagine Anthony probably feels the same about some of the case management measures, that will become business as usual. There will be others which have been very much linked to an emergency situation, which won't be adopted in the longer term. And they're the ones where we need to be really clear about, what does the transition back look like? So I haven't got that plan to share with you today, but I guess it's just to say we are working on it, and that's the direction we're heading in.
Good, that's great to know. We talked about obtaining client signatures before. Can you kind of elaborate a little bit on what auditors will consider sufficient in terms of trying to obtain but failing to obtain a signature but being allowed to continue with the case?
Yeah, so there is some, as you've already highlighted, Steve, there is already quite a bit of detail in the guidance that we've put out about what we would consider that to be. And I think that will be different depending on the circumstances of the case and the circumstances of that particular client. So the most important thing that you can do is to keep good records of the attempts that you've made, in addition, the express evidence that's mentioned in the guidance as well. So, the contacts you've had with the client, the email exchanges, telephone attendance notes, and it's about being able to demonstrate that the client formed the appropriate intention to sign and submit the application form, so that you can demonstrate that that was their intention. They wanted to apply for legal aid, and the reasons that you couldn't get the signature, are set out on the form and on the file. So it's difficult for me to give specific examples at the moment because, as we've said before, we've paused all our audit activity, so we haven't looked at any of these files in any capacity. So obviously we haven't done any core testing, and we haven't done any contract manager activity. So if things emerge from that, once we do start looking at files and there's more guidance we can give to providers, then obviously we will do that. But from my experience of looking at files, it's all about what's evidenced on the file, and as much information as you can put on there as possible. Okay,
thanks for that. We talked a little bit before about the supervisor's requirements, so for annual number of casework hours, caseloads, etc. Can you tell us a little bit about how that might be audited going forward?
Yeah, so I suppose the contingency guidance focused on the supervisor challenges for now, albeit the wording of it is obviously a broad one, so covers any kind of challenges that you've got in terms of meeting the supervisor requirements in the current pandemic. And obviously that has been extended to the end of July. So we, what we're saying is we appreciate the fact that you might not be able to meet the supervisor standards at the moment. If you can't, keep a record of that, and we can obviously discuss that with you. In the longer term, we know that this potentially will have an impact longer term. Hours is one of the ones that's been quoted as potentially being a problem, and that may or may not be an issue depending on the type of work that you do or whether you've been furloughed or not, because what we tend to see is people do far in excess of the number of hours that are required anyway in a lot of cases. But again, what we will need to do is set out our guidance around the position going forward as well. So we are looking at supervision as a whole, and looking at what does the transition back to normal look like, and we will give some really clear guidance about it, but we don't have that to share yet.
Yeah, that's fine. I think people will just be assured to know that there's a plan to publish something, so it will be clear, and people will have a kind of map back to where they need to be.
Yeah.
So that one's good. Just staying on supervisors, one of our clients did ask that will the LAA be more flexible than normal if firms lose a supervisor, given the current situation makes recruitment more challenging?
Yeah, so there is already some flexibility in the contract around if you've got a temporary absence of a supervisor. And I suppose it's, just to say, we will take into account any circumstances around, clearly the guidance at the moment says we won't take any action. That lasts until the end of July, and may well be extended beyond that. And yeah, we just need to know as much as possible what the challenges are that you've been having, and give us that information, and then we can look at what the contract says and apply flexibility where we can.
Okay, and just before we finish this section, I have a couple of crime related questions and one for mental health. So first up, on court duty attendances, I believe some of those are being conducted by telephone. That's okay to claim because it's not mentioned specifically in the guidance, and also does a provider claim for the whole period that they're on attendance, or are they limited to the amount of time actually spent on the phone calls?
So Essentially, yeah, so reasonable attendance time that they've spent on the phone can be claimed when they're acting as duty solicitor, but it would be by session. So anytime, it's basically any time spent on the phone that can be claimed.
So on my sessions 9 till 1, normally I'd get paid 4 hours, sat at court. But now I'm doing it by telephone and I'm only on the phone for 2 of those 4 hours. The claim would go in for 2 hours.
The time that you're engaged in your duty session, yeah.
Okay, great, thanks. And then when it comes to police station telephone calls, there's been a couple of queries around what auditors will look for to be able to differentiate between that standard telephone advice and what is a replacement for full face-to-face advice.
Yeah, so again, I mean, there is some further detail in the guidance about what we mean. So we've said, I'll read from what we've said in the guidance, which says that the provider may claim the police station attendance fixed fee appropriate to the location where they attend remotely, and their remote attendance goes beyond the advice normally provided under the telephone fixed fee, covers the advice and assistance usually provided in person at the police station. And then, so examples of this might include things like considering police disclosure where provided with the client, advising the client on their case for the interview. And we've also noted that where the advice and assistance results in the provider preparing a written statement under Annex B of the protocol as an alternative, then they can claim the police station fixed fee. Again, I'm sorry, it starts to sound like a bit of a stuck record, but I think it's about putting the justification on the file as well. So when you look at that guidance and you have to decide how you're going to bill it, it's about justifying on the file why you think that constitutes, a police station fixed fee rather than the telephone fee. And the more information you can put there around what actually happened and how that fits with the guidance, the better. But similarly, I can't give you examples because we haven't looked at any files yet. So
no, that's
we
fine.
do need to put out more detailed guidance. At some point, once we've started to look at files, then we'll do that. But it's difficult to say at the moment because we haven't got examples of this.
Yeah, I mean, it's interesting. The answer to so many questions is justifying good file notes can get you out of an awful lot of holes. But I think particularly for, crime providers listening today, this is a really important area because it is going to flag up on audit. People are going to be looking at your police station, remote attendances, and looking to find evidence on the file that they do qualify for the full attendance fee. So I would just urge you to take care in writing those notes and don't take any shortcuts, certainly. We did have
I think we've had an additional question about whether that will be a permanent position. So I don't know if you want me to cover that off. I think, so obviously at the moment we've had to be led by what's actually happening in the justice system. And at the moment, a lot of police stations are still dealing with things remotely. So this, this guidance needs to be there to support the work that providers are doing. I think, as with all the other contingency measures, we'll keep it under review and we'll be asking ourselves questions around, is this still necessary? How are things actually operating locally? And who knows what the permanent position will look like and whether, all police forces will revert back to our experience prior to COVID or whether things will be different in the longer term. So I think it's a case of watch this space really, but yeah, as we certainly know that for the next month, there's going to be no change to it, and I would be surprised if it changes soon after that because I can't see all police stations being able to revert back immediately.
Okay. Thanks, Jill. And we did get a question about an hour before we went live on mental health. Just to say that we had a provider with an example of work that was transferred out of their area, but with it being an existing client, they obviously can still see that client. And the client was in a new period of eligibility. They just wondered if it was acceptable to send forms to the mental health administrator in order to get the client to sign it. So I think, Anthony, you said you might have an answer on that one for us.
Yes, Steve, thanks. Yeah, that's absolutely fine. I mean, if the administrator receives the forms and ensures the client signs them, that's fine. But, just bear in mind the responsibility for ensuring forms are signed lies with the provider. So, it sounds like a sensible idea, but just have that in mind.
I guess there will be variation as well in terms of the administrator's willingness to participate in that. I know we've certainly had feedback that some providers have had pushback from some secure hospitals to say, we can't do this, it's not part of our role. So if it's an out of area one and not an administrator that you're familiar with, it might be worth contacting them in advance to say, is this something you're actually able to facilitate?
Okay, and there was a part B to that question as well, which was obviously if the client's not able to sign because of their psychiatric condition, the provider can be appointed under Rule 11.7b. Is that true?
Yeah, so litigation friend can sign, or if necessary, the supervisor of the provider. So we're quite happy to set out all the rules and regulations in respect of that. Okay, great. Thanks, Anthony. So we'll move on now to processing of claims. There are a number of contingency measures in civil which focus on the fact that the LAA is dealing mostly now with electronic correspondence rather than accepting papers. So for escape fees, civil escape fees, there's a streamlined process. At the moment, you would just need to send in your EC1 form with the case summary, copy of the means assessment, any disbursement vouchers, your running record of costs, and then any other information you feel is necessary for the LAA to look at with your claim. Where appeals are concerned, whether that's for certificated claims or escape fees, the LAA again are only accepting electronic appeals. If you're not able to do that and need to submit paper, there's a kind of open-ended delay on that until we hear further. Emergency payments for paper claims, your non-CCMS claims. The LAA has introduced a POA Contingency 1 form, POAC1, where you are allowed to claim 100% of your profit costs only at the end of the case. All you need to do is submit your running record of costs with your form. However, there will be a full assessment of that file at some later date. And within the LAA's contingency measures, they also highlight the FAS forms, advocacy attendance forms for family. These obviously we've been used to seeing more and more remote hearings over the last kind of year or two, and there's already a lot of guidance in there which will cover providers. In essence, you don't need to get the FAS form signed, the X506A form. Just an attendance note will cover that, and if there are bolt-on fees, then the attendance note should also cover those bolt-on fees. When it comes to crime, you've got electronic submissions of your CRIM 7s, which are your non-standard magistrates court fees, and your CRIM 18 and 18As, which are your escape fee cases, for police station and for prison law. Now with your CRIM 7s, it's worth noting that recent announcement last week says there's a return to business as usual from the 6th of July, which is next Monday. So if you do have some CRIM 7s to submit electronically, you need to get them in this week, and what you'll need to send in is your CRIM 7 form with a case summary, the MAT reference or representation order, disbursement vouchers, a note of your page count, and any information on assigned counsel with your CRIM 8. For your CRIM 18s, the police station escape fees, you'll need the form, CRIM 1 and CRIM 2, if applicable, if you're given advice and attendance, disbursement voucher, and a note of your arrival and departure times, along with a breakdown of travel times, waiting time, etc., and attendance notes for any attendance on the client. Your CRIM 18A, that's your prison law escape fee cases, you'll need to send in whatever relevance from the CRIM 1, 2 and 3, disbursement voucher, running records of costs, page count, and any representations and other key information. So I'm going to bring Anthony in now. We've got a couple of questions on this. The contingency process for submitting escape fee claims has made the billing process a lot easier for clients. Are you considering making any more permanent changes to that process? Yeah, thanks, Steve. It's a good question. I think Jill probably summed it up neatly with her children in the background. She probably summed it up neatly when she said that it's safe to assume that we're not going to go back automatically to the way things operated before. I think the landscape has definitely changed, I think, for us as an organisation, no doubt for every single person on the session this afternoon. In terms of escape cases specifically, we're actively looking now at the contingency we put in place to see how we can consider the impact of it, but also how then we move it to a business as usual process, which in my view, I think we should try and come up with something that's going to be digital. It doesn't make sense to go back to any processes that are paper-based, but we acknowledge that you know, that might be quite a significant leap for some providers, considering how files are run and the kind of the amount of paperwork that we've previously asked for. So we're actively looking at it. We're mindful of the position of providers, but if we can come up with something that is electronic, that perhaps uses secure file exchange or any other appropriate digital methods, then that's definitely the way forward for us. We think it's better for firms and certainly better for our casework team to do that.
Okay, let's hope for some positive news on that, because certainly the feedback I've had is providers find it a really good process now to work with. The other question we had in this area relates to the FAS form. So somebody has asked if you require a previous FAS form in family matters to be resealed to receive the payment, how are you dealing with this at present, given that the courts aren't there to reseal the form?
I'll invite Stephen to come in on that if he doesn't mind. He's one of our subject matter experts on the civil billing team.
Okay.
Yeah, of course. Thanks very much, Anthony, and thank you for the question. I think during this period, we are being as flexible as possible in line with the remote hearing guidance, which has been published. We will accept alternative evidence where it is available. And alternative evidence is usually a court order, but we will also accept an attendance note in lieu of the advocate's attendance form. And on that attendance note, we just ask that you put on the names of the advocates, the start and finish time, and any applicable bolt-ons. And obviously that will be sufficient. All that we'd ask is that you just flag in the document request or the upload exactly what the caseworker needs to look for, and just direct them to say, look, this is an attendance note in lieu of an advocate's attendance form, because we know the courts aren't sealing them, and that will be sufficient for us from an evidence point of view.
Okay, thank you very much, Stephen. So continuing with processing of claims, at the moment the LAA isn't accepting cheques, so the guidance will state that online banking is required for contribution payments. The LAA is taking a flexible approach where clients' financial circumstances change, so obviously clients might be furloughed, other reasons, their financial situation may change. The LAA have basically paused action in relation to enforcement, although the most recent update says they will start writing to clients again in July. The flexible approach, for example, in civil, show causes have been suspended for a period of 12 weeks, and firms are being given extra time in both crime and civil to obtain the evidence to prove the client's change of financial circumstance. When it comes to bills, the LAA are adopting an approach of rejecting bills only where information fundamental to the processing that bill is missing, so trying to make payment to providers wherever they possibly can. The length of time for submitting controlled work in civil has been extended. That's in the guidance, the usual 6-month period. Now, obviously, from your point of view, if you can get the claim in earlier, that's going to be more beneficial to you. But if you absolutely can't, it's going to cause a delay, then there's a kind of open-ended period for you to catch up as things stand. Now, crime LAA is not specifically mentioned in the guidance, but I've had a chat with Jill before we did this webinar, and she confirms that CMs do have the flexibility to discuss that. So if you're struggling to get in the office, make your CRIM 6 claims every month, then have a chat with your contract manager, and they will take that flexible approach in considering your circumstances. The final point is for council acceptance forms as well. The LAA are currently allowing acceptance by email. So again, I'm going to bring Anthony in just to see if he's got any comments to make on that particular slide. But also we have had a question in which relates to the rejecting of bills. Now, prior to the pandemic, the LAA had announced that they're going to slightly change the way in which they're going to measure claim rejects, claim 1A rejects, so that some previous document requests which weren't counted as a reject will now count as a reject towards your KPI. And the question on that was really around how are you planning to implement that, and given everything that's gone on in the last few months, will there be a kind of soft lead-up period where providers will be given a chance to adapt to the new criteria?
Thanks, Steve. I think it's another good question, and I'll invite Jill to come in on particularly the kind of contract management approach to it. But I think just a couple of things worth setting out in terms of rejects. I mean, firstly, we're rejecting far fewer bills than we have for a significant amount of time, which I think is really worth noting. What we're talking about here principally is just trying to increase the number of bills, or in fact, agency, what we're trying to do is increase the number of transactions we can process first time. So we really want to drive down any additional work for providers and for us as well. And one of the things that has been really apparent over the last couple of years where we've really shone a light on this is that a number of firms just aren't aware of the holistic performance of their firm in terms of the number of bills that are not being paid first time. So there'll be routine conversations with contract managers about their performance in relation to KPI rejects, but perhaps less of a focus on anything that might be considered a non-KPI reject or even a document request. And what we have found is useful is that providers have sight of the full picture, so they can see the number of bills that are not being paid first time and what those reasons are. I mean, in fact, for us internally, there isn't any difference between a KPI reject and non-KPI reject as a document request. There's a bill that we can't pay first time, and for us that's a problem. We're going to try and work with providers and with our caseworker teams to ensure that we do pay more bills first time than we have done in the past. And interestingly, if you go back about 18 months, if you add up the number of rejects, KPI, non-KPI and document requests, we would probably send in back nearly half of all bills that come to us, which was just far too high. It was far too much work for us, far too much work for providers. But at the same time, the published KPI performance was around 5-6%. So, you know, a lot of the conversations were probably quite positive about what the data looks like, which probably didn't actually match the experience of providers out and about on the ground. That overall return rate is down now to about 20%, and it reflects probably the best position we've got to in the paper world. But we still think it's too high, and we really want to continue to drive that down and pay more bills at first pass. So that's the kind of motivation for shining a light on the kind of full holistic picture. I imagine that contract managers will be quite reasonable about this. This is about kind of giving the information to providers and about trying to help and so that we can work together. But I'll invite Jill on that point.
Yeah, just agree with what Anthony said there. So the change in the data is about giving you that visibility. And I think just the recognition that now more than ever, you will want your bills to be paid first time where that's possible. So the more visibility we can give you of your firm's data and, you know, how many bills are paying first time and how many, you know, need to be returned for whatever reason, or we need to ask for additional information, has got to be a positive thing. From a contract management point of view, our priority at the moment is to continue to work with you to understand what the issues are for your firm, to resolve the reasons for the rejects, and to increase the number of claims that can be paid first time. So I think, yeah, you know, that's the phase that we're in, is basically, you know, giving you the visibility of the data, talking to you about it, and, you know, working on getting it right. And I think it's a conversation with your contract manager to say, if you have got an issue, how can we fix it? Are there ways that we can help you to fix it? Because, you know, we do have some training materials, and our colleagues in case management have done some, you know, webinars that have been really well received. So I think, yeah, have a look at the data. It is on your PAR report that you can access, you know, every month. So have a look at it and, you know, talk to us if there's anything we can do to help you with it.
Yeah, thanks, Jill. And obviously this is a win-win area, isn't it, for providers as well. So an area that they should want to be as compliant as possible with. One of the areas we did get a lot of questions in is about the transfer of assessment from court to the LAA. A few providers flagging some concern over how that might be handled. So I think, Anthony, you're just going to take us through this slide, aren't you?
Yeah, thanks, Steve. I think I won't go through the slide in detail, but there are a couple of things I think worth picking out. Hopefully people will have seen the guidance in terms of submitting claims to us. I mean, we've really tried to be as flexible as possible to providers in terms of getting the information to us. I mean, we recognise that what we want to do is just to make it easy in the current situation. I think that's kind of a really important point we want to make. Another couple of key points, because I know that rep bodies have raised similar issues, and we're going to come out externally with some additional information on some of these things. But principally, the motivation for bringing the work into the LAA is to help providers during this current crisis. I mean, we've attended a number of conversations with rep bodies, providers, and HMCTS where we've talked about this, and we really noticed an issue during the height of the pandemic, where the number of court assessed bills that were coming into us as an agency were really dropping significantly, and that reflected what HMCTS themselves were saying and what providers were saying, which is that, you know, the priority for them had to be vulnerable clients, and this wasn't going to be a priority area of work for them. And we recognised quite quickly that the potential impact on providers is significant in terms of cash flow. It's useful to say that actually the LAA has wanted to do this for a number of years. So whilst it looks like it's a quick decision, we've actually been in conversation with HMCTS for a while about this. We've been looking to upskill our caseworkers, and we're regularly used to assessing high value claims, and we're confident that we can continue to do that at a really high standard. You'll all be aware, of course, that kind of the average time for the court assessment process for HMCTS is about 4 months. Well, our turnaround times on kind of civil billing have been on or around day 5 for at least the last 3 or 4 years consistently. So, you know, that would mean that we will be able to get funds out to providers really quickly if the claims are submitted to us. We've already seen well over 200 tax bill or court assessed claims come to us without going through the court assessment process. Almost all of them have been paid without any issues at all, which is really positive, and we've had some really good feedback from those providers that have taken up that offer. So I just wanted to say that, I mean, we are still talking to HMCTS about when the transfer becomes formal, so it will become mandatory for claims to come to us, and you can expect to hear more from us on that over the next week or so.
Okay, thank you very much, Anthony. Now we're going to look a little bit at the financial support that's been made available to providers. And this is financial support outside of all the government schemes you'll be aware of. The first point really though is to reiterate that there have been no changes to the reconciliation process for standard monthly payment or variable monthly payment. I've certainly had a few queries in from our clients about the standard monthly payment protocol, but just to reiterate that as things stand at the moment, that protocol will still apply in terms of when over or under payments will trigger an increase or a decrease in your payment. The main areas of financial support to providers, firstly for civil, have been through payments on account. So we talked earlier about how we've got the payment on account contingency form that you can use for cases at the end of their case. While cases are ongoing, the payment on account rules are pretty much as they were in terms of 75%, etc. But the LAA are about to announce an increase in the number of payments allowed in the 12 months from 2 till 4. And this isn't going to be a temporary measure. This is going to be a permanent change to that process. So there'll be a lot more opportunities throughout the year in order for you to claim those payments on account, increased cash flow opportunities. When it comes to crime, the main opportunities are interim payments in the Crown Court and hardship payments. So for interim payments, these are available under LGFS, and there are 3 stages at which you can claim these. That's first hearing, when there's a not guilty plea. Second, upon the representation, when representation is transferred to a litigator in a retrial after the date of the retrial has been set. And thirdly, at the start of a trial when that trial is expected to go on for 10 days or more. Interim claims are made via the CCD online system, and you need to send in evidence of your PPE, your LAC1 form, representation order, and details of the indictment. One key point to note is that you can't claim for travel under the interim payment scheme. You have to wait until the end of the case for your travel claims. Hardship claims in Crown Court matters, the regulations were amended on the 1st of May. In order to qualify, you have to be working on the case for more than a month and have to have run up costs in excess of £450, exclusive of VAT. You've got to state that you're unlikely to receive payment 3 months after the claim, and the final criteria is that you'll suffer hardship. However, where reasons for the claim are COVID related, the LA isn't requiring additional evidence, so usually they'd ask you to kind of prove that you're suffering hardship by, for example, showing your bank statement. Where it's because cases are being delayed, postponed due to COVID-related reasons, those reasons are just being accepted. Again, you submit these claims via CCD online, where you need a copy of the representation order, case details, offence type, PPE, and number of defendants. That'll be all the information you need to provide. A couple of smaller points I think to make for prison law providers, where you incur costs for setting up a video link, you can claim that as a disbursement. If it's over £20, make sure you've got the voucher. And for travel, you have to justify use of car, particularly during business hours. The LAA are now accepting that more providers will be using the car if you're using it because of a lack of public transport or because of concerns over health and safety, then that will be an acceptable reason. The LAA will also accept travel from home rather than office, where that distance is further, understanding people are working from home. And the congestion charge, if you're outside of the congestion zone and you'll be travelling through it, where your office is usually in it, you normally can't claim that fee, but for the period of the pandemic, if it's because you're working from home, then you are able to claim that. So I'll bring Jill in at this point. One of our clients has actually asked about disbursements for controlled work and asked if there are any plans to bring in a kind of payment on account system for that sooner than the current 6 months time limit. Is that something that you're considering?
Yeah, so we are considering that, looking at the payment points for disbursements and also the payment points for controlled work more generally, specifically in a specific number of categories where cases have been impacted by the pandemic and have been delayed significantly. That is a piece of work that's actively ongoing at the moment, and obviously as soon as we can share anything with providers, we will do.
Okay, thank you. Now the LAA conducted a financial survey kind of the end of April, early May with their providers. Can you give us a flavour for kind of what that told you and what measures the LAA is considering for possible future financial support?
Yeah, so first of all, I guess just a big thank you to anybody who's on the webinar who participated in the survey. The information has been really, really useful for us in terms of being able to understand the impact of the pandemic on providers and also to communicate that to other people outside of the LAA. So, for example, colleagues in MOJ policy. It obviously also has a purpose for contract managers because they need to be able to understand what's happening with their providers in their portfolio, and for us to be able to look at, what are the impacts on provision if, for example, providers aren't currently taking on cases. So that's been really, really useful. We're currently looking at whether we can share some headlines from the survey. Obviously, extremely conscious of the fact that there's lots of very commercially sensitive information in there, and that we would only even consider sharing something if it was at a level that, obviously couldn't identify anybody and, just gave some very, very general sort of views about the impacts on the provider base. So we are talking to the rep bodies about that. So again, sort of watch this space on that one, I think. But yeah, and for example, the 4 times a year payment on account was something that came out really sort of loud and clear through the survey. Providers saying this is something that would be really helpful to us. So it's obviously helpful for us to have that information to be able to say, this is something that providers really want. And obviously, that is something we are in the process of implementing.
Okay, thank you. We've had a couple of more specific questions in this area. So one of our clients has said, given that there's potentially an increased risk of firms shutting down or going into administration over the next few months, can you outline what process there will be for firms who are wishing to take over those contracts and what happens to the existing clients? Are you looking at putting any special measures in place because of COVID?
Yeah, so in terms of the providers closing and potentially wanting to restructure or merge with other providers, and we do have a current process and policy for that. And the first step is to contact your contract manager to say this is something that you want to do, and we'll provide you with the relevant forms. Where possible, we ask for you to give a month's notice so that we've got time to properly review all of the detail and ask for any more information if we need it. But obviously, if that's completely impossible because of the current situation, then just contact us as soon as you possibly can with all of that information. and the sort of position around ovations are set out in the contracts themselves. So that's the best thing to do in terms of looking at what will be possible. In terms of where if providers do close and sort of what happens to clients, again, we already obviously experience that in sort of business as usual situations. So my understanding is the onus is on the provider to notify their clients that they're closing and to let them know that they can seek alternative representation and obviously transfer the file to the new provider if that's happening. Our role in that is understanding what is then the impact of that on provision in that area, and working, if it's relevant, working with our central commissioning teams to say, does that cause us an access gap or an issue with provision, which obviously will be different depending on what the situation is in that particular area.
Okay, thank you. And another question, I guess along similar lines, is there any change in your guidance towards CMs in terms of awarding new matter start increases? I think particularly, for example, if providers are closed, whether it's temporary or whether it's permanent, or are offering a limited service, and so the supply in an area is reduced.
Yeah, so it's not something I don't think that we've particularly seen yet in terms of requests for increases. Obviously, there is flexibility in a lot of the contracts currently in terms of being able to self-grant. And if you're unsure about whether you can grant additional matter starts, your schedule will set that out. But if you're not sure, just contact your contract manager about that. If you need an increase that goes beyond what's allowed in your schedule, then again, just contact us with as much information as you possibly can. And if there are COVID-related reasons why there's been an impact on your numbers of matter starts, then just set that out really clearly for us.
Okay, thanks, Jill. So I think we've just about done an hour, so we're going to slightly overrun, but not too long for people who are listening, because this is the final slide really, and it's what comes next. So I think Jill's already said that the LAA is fully aware of the need and will continue to publish a roadmap to how and when guidance will change. And something that Jill has said a couple of times, but just to reiterate that the current guidance is valid until the end of July. That doesn't mean that guidance stops at the end of July. Some areas are very likely to be extended further beyond that date. So I'm just going to bring Jill in to talk about a few things. So first of all, the LAA are going to run some workshops later in the year.
Yeah, so this was something we started planning before the pandemic, and the initial intention was that we would do them face to face, and that it would constitute sort of training and information on different areas of work. We're now looking at that again and seeing whether we can do that, by a remote method, and hopefully, we'll be doing that in the autumn. So if there are particular areas that you're interested in, then feel free to, let your contract manager know, and we can incorporate that. But we'll be trying to, focus them on the areas that we get a lot of questions about or that we experience issues in. So that's the plan for workshops.
Okay, thanks. And can you tell us a little bit about the Apply service as well?
Yeah, so I just wanted to very quickly mention this today. It's entirely unrelated to COVID, but it's something that, again, we've been working for quite a while, and it's essentially a new interface or application system for providers to use to make applications with the LAA. It's currently being used by some providers, so specifically for domestic abuse cases. We may even have people on the line who are already using it. And so we're piloting it in a very limited way, and we will, based on the feedback from users, we'll be looking at it and iterating it and rolling it out, and to add different categories and different areas of law. So again, look out for sort of further updates on that. But the feedback from providers who've been using it is really positive in terms of how user friendly it is. And the aim is that we have sort of direct link ups to other agencies such as DWP and HMRC, so that we can significantly reduce the amount of evidence that clients are having to gather to be able to apply for legal aid. So that's just something that's on the horizon that I wanted to mention.
Okay, good to know about that. And finally, I've left the big one to last. So obviously both the crime and the civil contracts expiry dates are due next year. Is there any update you can give us about the tenders?
Yeah, so I feel like waiting till last, and I think it's going to be quite a disappointing answer, but unfortunately there's nothing I can say today in terms of definite timelines for a contract, but reassuring you that we are actively looking at it, conscious that there will be providers and individuals who have different views about what they want here. Some providers would prefer extensions and to give them further certainty and not have to go through a tender, and there'll be other providers who, either as a result of the pandemic or completely unrelated, are interested in applying for a contract and would like the opportunity to do that. So that is a piece of work that is actively ongoing at the moment, and as soon as we can share anything with you, we will.
Okay, thanks. And I appreciate it's difficult because ultimately these decisions will be taken at much higher level or by politicians, and at the moment what's going to happen generally out in the world is a big question mark over huge areas of kind of public expenditure, isn't there, I guess. I think our advice on this would be, particularly in relation to crime, which is due up first, if there was to be a tender for contracts in April 21, you would expect to see the IFA and the ITTs being published in the next 6 to 8 weeks. We're getting no kind of signals that anybody's starting to think about writing those and what might be in there, so you can probably draw your own conclusions about the likelihood of that taking place over the next few weeks, given everything else that the LAA have got to contend with, and obviously you as providers. So thanks for that update, Jill. Finally, just before I hand over to David to see if there are any questions he wants to ask, if you do think of any questions over the next 2 or 3 days and you want to submit them to us via email, can you send them to the address here, teamadmin@dglegal.co.uk. By the end of the week, we'll collate any of those questions together with any questions that have appeared on the chat function we've not got round to today. And in conjunction with the LAA, we'll look to produce a DG Legal Q&A on those particular areas. Useful resources, these are really the links to the main headline pages on the LAA guidance, so you can have a look at those and drill down and look at the more detailed guidance within each of the relevant sections. And finally, if you do have any queries or you want any support in dealing with the LAA or understanding their requirements, if you're not a regular client, then obviously you can contact us via info@dglegal.co.uk if you'd like to chat to someone further about that. Okay, so I think I'll hand back to David now, and thanks to the people from the LAA. Thanks for your attendance today.
Okay, thanks very much, Steve. Now, in terms of questions, we've had rather a lot of questions, and I think if we were to do all of them, it would be around about half an hour. So I think what we should do is just pick 2 or 3 questions to answer now, and we'll answer the rest of them after the webinar. So the first question that was asked was, will we be providing slides? Of course we will, and we'll give you a link to the recording. And Anthony, Stephen, Jill and Stephen, I don't know, can you see the chat questions?
I can't, I'm afraid.
No, I can't, no.
Okay, so I should read a few out then. So the first substantive question was about training. So the question is, what is the position regarding continuing competence? It's hard to attend a course at the moment. Well, I suppose I can give the answer to that one, and perhaps ask the LAA to comment on LAA position. But in relation to the SRA, because of course continuing competence is an SRA concept, I don't think there is any change. So for instance, this webinar and the previous webinars that we've delivered over the past few weeks would all be included in continuing competence and should form part of your training record. And I guess the ability to attend webinars is arguably easier now that we've got used to things like Teams and Zooms, etc. So I wouldn't expect the SRA to relax their requirements. And of course, continuing competence was all about making you think about what is appropriate to retain your knowledge, skills and experience, rather than the 16 hours a year, which some sort of say tick box exercise. Jill, would you have anything different to comment from an LAA perspective? Would you expect them to attend face-to-face, which of course is impossible?
Yeah, nothing to add. I mean, as you say, it's not an LAA requirement, so it's not something that we would, actively look at routinely anyway. So, but I think, what you said is certainly sounds sensible, that yeah, if the training's available and you can do it remotely, then carry on and do it.
Now, I'm not sure whether you have covered this next question because it's very similar to what you were talking about. This is relation to crime. How can you get signature of remote interviews at police station and court and clients in prisons?
So I think that's, I'm probably sort of half guessing what the question's driving at, but I think that's covered by the guidance because we cover the scenarios where you don't get a signature at all.
Okay, that's fine, and we'll further confirm that in writing along with a link to the guidance.
Yeah, so I think the guidance looks at, you know, can you get a digital signature, yes or no? And if the answer is no, then the guidance says when can you proceed without a signature? And it's all around providing details of conversations, email exchanges with the client.
Okay, the next question is, in fact, the next two are mental health questions. Has a decision been made about whether claims can be made for adjourned MH tribunals when you are tendered with the panel remotely, but the case has not proceeded and has been adjourned for a tribunal on a future date, and the tribunal does take place on that future date?
I don't know. I'd have to ask somebody more expert in mental health claims, but we can follow that one up.
Okay, let's just have one last question then. This is a crime question. How and when are the legal aid agency going to resume checking for ghosts on duty solicitor schemes, both at court and police stations?
Yeah, so I guess this relates to the 14 hours requirement, which at the moment we've obviously said, you know, we will apply flexibility to, and that we won't take action if the reason that you're unable to meet it is because of COVID. It fits into what we were saying before, so it's one of the things that, you know, we will need to look at and decide at what point is it reasonable for us to revert back to, you know, the previous position. And if it is reasonable, you know, what does the transition look like, you know, to a sort of BAU position? But I think if I was a provider, I would want some notice of that and want to be told, you know, this is going to happen in X months' time. And, you know, but the most important thing you can do now is keeping the records, because that tends to be where we see the problem, is just that the record keeping isn't there. So if your records are there and you've described the reasons why your duty solicitors aren't meeting the 14 hours, you've been clear about, you know, what the impact's been on them, whether that is just because of volumes of cases or because of furlough, or you know, people have been unwell or in isolation, all of those things. So just keep as, you know, as much information as you possibly can, and we will be clear about, you know, at what point are we going to start looking at it again.
Okay, thank you, Jill. And thank you, Steve, Anthony and Stephen, for your time this afternoon. Just to reiterate, there are many other questions that have been asked, which we will answer very shortly. And those Q&As, together with a recording of this, will be on our website within a few days. I'd just like to finish up by mentioning the next two webinars that we've got lined up. This Friday, the 3rd of July, we have a training session for immigration practitioners, which is called Use of My HMCTS for Immigration Appeals. We think this is really important because from the 22nd of June, the Tribunal's new online platform became mandatory for most immigration appeals. It is causing headaches for practitioners, and the purpose of this webinar is to assist firms to understand how to navigate the online platform. It's presented by our LAA Immigration Award winner, Amy Higgins, and also Chris Cole, who sits as a fee-paid immigration judge and has presided over numerous reform appeals. And then next week, on Thursday, 9th of July, we have a webinar which we've put together for CLSA and LCCSA and all crime practitioners, which is called A Guide to Peer Review, featuring one of our colleagues, Jeff Bell, who is an ex-senior peer reviewer and is managing partner of Stevens Solicitors in Stoke. And we will be announcing fairly shortly details of other webinars which are in the pipeline. And if anybody has any suggestions about topics that we can cover over the coming weeks, we would be delighted to hear from you. So once again, I'd like to thank the presenters, and also thank you the very high number of attendees on this particular webinar. We had well over, I think, 120, and we still have got over I think 96 still on the webinar now. So I'm going to end the webinar. In fact, yeah, I'm going to end the webinar now, and we look forward to answering your other questions. Okay. Bye for now.
Bye. Bye.
Thank you. Bye.
Thank you.
Cheers.